of Tennessee is in session. Please be seated.
Good afternoon, and welcome to the afternoon session of the Court of Appeals. I'd like to introduce our panel for this afternoon. To my right, Judge Armstrong from Memphis. To my left, Judge McGee from Savannah, and I'm Judge Golden from Memphis. Do we have any announcements or anything we need to address?
No, Your Honor.
All right. Will you please call the first case?
Sheila Roberts on behalf of Thomas Sam Edwards versus Nathan Hinkle, M.D.
Your Honor, I'm here for the appellants and ready to go.
All right. And your opposing counsel's here. I'm sure all of you know the procedure here. Each side has 15 minutes. The appellant can request rebuttal time of up to 5 minutes of the 15. So when you approach, just announce how much time you would like to reserve if possible. You may step forward.
I'll do 12 and 3.
3 minutes? You want
12
to
and
reserve 3
3?
minutes?
Yes, I'll reserve 3 minutes.
All right.
All right, may I proceed, Your Honor?
Please.
All right. First of all, by introduction, my name is Dan Szymanski. I'm with Chapman, Lewis, and Swan in Clarksdale, Mississippi. I've been up in front of not this panel, but other panels in the past, and it's good to be back. This case involves service of process issue. The rule specifically involved is 4.04, subsection 1. And I'm just going to get straight to it. The direct question in this case is whether or not the gentleman that we served, that the appellant served, the appellant's process server served, a gentleman named Dangelis Padden, whether or not he was an authorized agent to accept service for a Dr. Hinkle in Memphis, who's with the University of Tennessee Health Sciences Complex. And our position, of course, is that he was an authorized agent, and for these reasons. Number one, Mr. Padden was at the time of service in October of 2020, which I would remind everybody was back during the pandemic, was right when the pandemic was going pretty good then. There was a lot of lockdown things going on. Mr. Padden was the director of operations for the University of Tennessee Health Sciences Physicians Group. He was he was a director over a number of physicians, including Dr. Hinkle. So he was in a position of authority, actually authority over the physician. And in this case, when the process server went to serve Dr. Hinkle, before he went, he actually called Dr. Hinkle's office and alerted them that he was coming and he had papers to serve. And Dr. Hinkle had 2 offices, one in Germantown and one at the UTHC campus downtown. And so when the process server, Steve English, when he called, he was advised that Dr. Hinkle was at the downtown office, which was the same address as was on the summons for the service of process. So he went down there, a process server, to serve him. And of course, back then you can imagine you had to sign in just to get into the hospital. You had screens between you and the people working there. And so according to our process server, when he asked for Dr. Hinkle, they got back from the partition and started talking with each other, and they said that he was not available. And he then, Mr. English then, who was a deputy for DeSoto County, this gentleman, the process server, is a deputy. He called the office again and was told that, no, Dr. Hinkle should be there. That's where he's seeing patients, and you're in the right place. And when the process server went back in and asked again, he was told that Dr. Hinkle was not available. And so the office administrator for Dr. Hinkle's office called Dangelis Padden. That was the person that they called to come up to take care of the service of process. Mr. Padden, as I mentioned, he was the director of operations. He came in, and we actually took his deposition, and it's cited in the brief. Mr. Padden explains why he was the one accepting service. He was requested to do so and told to do so by his senior director, I think it was Mr. Jenkins, So he had been advised by his superior there at UTHS to go and be the one to accept service. This is who the doctor's office called to accept service, and he showed up and said he could accept service. And so at that time, the summons is part of the exhibits that are on the appeal file. Mr. Haddon signed on behalf of Dr. Hinkle, and when we took his deposition, just a number of years after that occurred, just in response to this particular motion, when we took his deposition, at that time, even at the time of his deposition, he testified that it was his understanding he was the one for UTHSC to accept service, and that he wasn't at that time authorized to accept service. So in this case, our position is, and let me back up. Part of the procedure or protocol is when they accept service to then get that service to the physician who's being served, which he did. He testified that he did do that. Mr. Padden got the summons and gave it to Dr. Hinkle. And what's important about that is that Dr. Hinkle never said to him, oh, wait a minute, you're not supposed to accept service for me or for us or for somebody. Dr. Hinkle never at any time opposed this gentleman accepting service. In fact, that's the gentleman that his office called to accept service. So with those facts, the only fact that contradicts that he has authorization is in a 6-paragraph affidavit by Dr. Hinkle. One paragraph makes a conclusatory statement and says he was not authorized to accept service. It's just a conclusion. It's the only thing he stated, no facts to back it up. Didn't put in his affidavit where he was or anything like that. He just said this gentleman did not have authority to accept service for me. But the facts, the uncontradicted facts, show the opposite. He was the designated person to accept service. He was called to accept service, and when he showed up, he did accept service. And when he turned the service over to the physician, there was no objection to him having accepted service. He was not told, hey, you shouldn't do that. Hey, don't accept service for me anymore. You're not authorized to do it. There was nothing. There was acquiescence by the physician. And so we filed the case, and we went through discovery in the case, and then several years after that is when the motion was brought forward, because by that time it would be too late to file.
I'm sorry, you said Mr. Patton was a designated person to accept service. Who
Yes.
designated Mr. Patton to accept service?
Mr. Jenkins, the senior director at the University of Tennessee Health Science Services.
And when he accepted service, how did he sign that?
He signed it. He signed his name, and it said accepting on behalf of Dr. Nathan Hinkle.
Okay.
And this is my prime. There is a part of my brief that discusses evasion, and the thrust of my argument is that this was an authorized agent who accepted service, and service is good for that reason. But if we get past that one, the other argument I had was in the two offices giving conflicting stories as to where Dr. Hinkle should be, that in that case, that would be an example of evasiveness of attempting to evade service, because one of the other things that was written on the summons that you'll see as part of the record was written by the process server, and it says they stated they were expecting this. They knew that, of course you have to give notice, written notice, and that they knew the lawsuit was coming, and knowing the lawsuit was coming, getting different conflicting stories as to where he was. And in his affidavit, there's no testimony by Dr. Hinkle as to say, oh yeah, I was there, oh I was busy with the patient, oh I was out of town, oh I was homesick, whatever. That's never been addressed by him in his affidavit. So all we have is a testimony from Mr. Padden, who said, yeah, when I asked the office administrator, where's Dr. Hinkle, they said, well, he's unavailable. That's all they would tell him. And so my argument in that context is that is evidence of him being evasive, and that would be another justification under 404 to leave the summons with Mr. Padden there, who's the director of operations.
Was Dr. Hinkle an employee of UTHSC?
Yes, yes. And Mr. Padden oversaw Dr. Hinkle's office, which was the Division of Surgical Oncology. He regularly dealt with them. They knew each other. They knew who each other were. It wasn't a stranger. It wasn't a customer service rec. Hall is the case, the Supreme Court case here in Tennessee that is, well, I see I've gone over my time, so I'm going to wrap it up right
still have
there.
time.
Oh, is this?
It turns to red.
Okay, it turns red. All right, I was doing the math in my head. My mistake. Hall deals with a customer service rep who's sitting out there for the physician who signs for a summons. And the Hall case discusses a number of things. And the first thing they say is, well, this person who signed, this customer service representative, even though employed by the practice, did not know what she was signing for. Well,
Let me ask you a question, and I understand your point that you're trying to make about Hall and the different classification of the person who accepted the service. But if I remember correctly from reading your briefs, your process server did not ever make any actual contact with the defendant, with the doctor.
That's
Is
correct.
that correct?
Yes.
And so if I follow your argument then, when you say that the defendant was evading service, you're basing that upon the actions of a third party.
Yes.
Do you have any case law to support your proposition that the actions of a third party can be used to determine that an individual defendant is evading service?
I do not, and I do not know.
Okay, thank you.
And going back to my point, my primary point is that we serve the authorized agent. I recognize my evasive service argument is not the strongest argument, and that's why I almost didn't even put it in there, but I felt there was some circumstantial evidence of evasiveness, and I thought it was worth putting in for that reason. I do not have any direct evidence of evasiveness. But my primary point being with regard to the authorized service and Mr. Padden, this is who the UTHSC, who they decided should accept service. This is during a pandemic when things are, you're not getting person to person. This is who Dr. Hinkle's office called to accept service. He thought he was authorized to accept service, and he was never reprimanded when he did accept service and turn it in, ever reprimanded. I asked him up to that day, up to the time of the deposition, several years later, were you ever given a memo, anything saying, hey, you shouldn't do this anymore? And he was, and that showed acquiescence.
Did Mr. Padden and his boss, I assume you took their depositions, did they both testify that they were authorized to accept service?
Mr. Padden did, and that's part of the record. I never took Mr. Jenkins' deposition because there's nothing contradicting Mr. Padden's testimony. Mr. Padden testifies about specifics, who said what, who gave him authority, and that's never contradicted by any of the affidavit or anything by Dr. Hinkle. It's uncontradicted.
But he indicated in the deposition that he was authorized to accept service?
Yes, Your Honor.
All right. You'll have your rebuttal.
Thank you, Your Honor.
May it please the court, good afternoon. My name is Natalie Bursai. I'm an attorney with Lewis Thomason Law Firm, and I'm a member of the Memphis Bar. I'm here on behalf of the defendant appellee, Dr. Nathan Hinkle. As your honors know, this case is before this court based on the grant of a motion to dismiss Dr. Hinkle from this lawsuit due to a finding of insufficient service of process. We're asking that this court affirm the trial court's ruling and the dismissal of the lawsuit against Dr. Hinkle. It's our position that Dr. Hinkle was not served with process in any manner consistent with Tennessee Rule of Civil Procedure 4.04. Substitute service was improper because Dr. Hinkle was not evading service of process or attempting to evade service of process. Additionally, even if it's found that Dr. Hinkle was evading service of process or attempting to do so, the person who was served with the summons or the person who signed the summons did not have authority to do that. By way of background, this is a healthcare liability action that was filed against Dr. Hinkle and originally also against Methodist Hospital. The summons that was issued with the complaint directed to Dr. Hinkle was addressed to his attention at the University of Tennessee Health Science Center, Department of Surgical Oncology. The return summons says that the process server served the chief of ops at Methodist Hospital Healthcare. The handwriting does say accepting on behalf of Nathan Hinkle. I will note that the person who signed the summons, DeAngelis Payton, testified that was not his handwriting, that he was not the one that would have written that. The person who signed was later identified to be DeAngelis Payton that we've been discussing. Dr. Hinkle was never personally served with the complaint. We filed an answer on behalf of Dr. Hinkle asserting the affirmative defense of insufficient service of process. At no time after the original summons was signed by Mr. Payton, and at no time after the answer was filed asserting the affirmative defense of insufficient service of process, did plaintiff reissue summons or attempt to serve Dr. Hinkle personally. Once a year had passed since the issuance of the summons, we filed a motion to dismiss on behalf of Dr. Hinkle that was granted by the trial court. There was a little bit of discovery in between.
Let me ask you, at the time that you filed your answer asserting the affirmative defense of failure of service, had the statute of limitations expired?
It had not. Well, at that time, the statute of limitations may have expired, but at that time, the plaintiff still could have relied on the filing of the original complaint if summons had been reissued when the answer was filed.
Okay, thank you.
Following the filing of the motion to dismiss, we did engage in some discovery. Plaintiff took the deposition of DeAngelis Payton, who signed the summons, and also filed a response relying on the affidavit and the deposition of the process server, Steve English. We deposed Mr. English before our motion to dismiss was heard and ruled upon. Tennessee Rule of Civil Procedure 4.04 outlines how an individual can be served with process. It says an individual other than an unmarried infant or an incompetent person, which we don't have here, can be served by delivering a copy of the summons and the complaint to the individual personally, or if he or she attempts to evade service of process or evades service of process to another person, the pertinent one here being delivery of copies to an agent authorized by appointment or by law to receive service on behalf of the defendant. Service of a summons directed to an individual but served on someone else is called substitute service, and Tennessee case law makes it clear that substitute service is only appropriate on an individual when an individual defendant evades service of process or attempts to do so. The burden of proving that an individual evaded service of process or attempted to do so is on the serving party. Additionally, a review of the actions of individuals other than the defendant doesn't meet this burden. The person's actions who are the focus of this analysis are the defendant. The defendant needs to be the one who is evasive. Here, the trial court correctly found that Dr. Hinkle, the plaintiff hadn't met that burden, that Dr. Hinkle was being evasive or attempting to evade service of process. The facts relevant to this analysis largely come from the affidavit and from the deposition of the process server, Mr. Steve English. Mr. English testified in his deposition that he called Dr. Hinkle's one of his two offices on the day that he was going to serve Dr. Hinkle and asked where he would be, and he was directed to a particular address. And so when he went there, he said that the person there started making phone calls and speaking with other people in the office. His affidavit says that the people in Dr. Hinkle's office appeared to be evasive when they were asked about Dr. Hinkle's location. The record shows essentially they were speaking to each other and making calls. It certainly does not demonstrate any evasiveness on the part of Dr. Hinkle individually. Mr. English actually confirmed that he never saw or spoke to Dr. Hinkle, and he also confirmed that he himself did not have any belief that Dr. Hinkle was being evasive when he served the summons. Essentially, there are no actions that are attributable to Dr. Hinkle in the record that can show that he was being evasive. The plaintiff has not met the burden of proving that Dr. Hinkle was evading service of process or being evasive when attempted to be served with process, so dismissal was appropriate. At that time, when the motion to dismiss was heard, since 1 year had passed between the issuance of the summons and the time of the hearing on the motion to dismiss, and plaintiff hadn't reissued summons, a dismissal with prejudice was appropriate. I will note that I don't believe that's being disputed in this case, that dismissal with prejudice would be appropriate if a dismissal is appropriate based on insufficient service of process. So we're asking the court to affirm the trial court's ruling that the plaintiff didn't meet the burden of proving that Dr. Hinkle either evaded or attempted to evade service of process, and the dismissal of the lawsuit based on that. In granting the motion to dismiss, the trial court also recognized that the plaintiff had not met the burden of proving that DeAngelis Payton had authority to accept service on behalf of Dr. Hinkle. Our position is that this finding was proper, but that this court does not need to reach that analysis because plaintiff hasn't met the burden of proving evasiveness or attempt to evade. But in the event that the court does reach this analysis, Tennessee Rule of Civil Procedure 4.041 states that when an individual evades or attempts to evade service, service can be made by delivering copies to an agent authorized by appointment or by law to receive service on behalf of the individual served. Actual notice does not excuse the failure to properly serve an individual. And when a purported agent of an individual is served, the burden of proving that that purported agent actually had authority to accept service of process falls on the serving party. Authority to accept service of process can be either express or implied. Here, it's undisputed that there was no express authority on behalf of Dr. Hinkle to allow Mr. Payton to accept service of process for him. Both Mr. Payton and Dr. Hinkle have put on the record that there was nothing direct from Dr. Hinkle to Mr. Payton to accept service of process. There's also no implied authority to accept service of process by Mr. Payton on behalf of Dr. Hinkle. Implied authority can be established through a course of conduct, and the course of conduct, the focus of that course of conduct is that it's between the principal and the agent, but it's predicated on the actions of the principal rather than the actions of the agent. The analysis focuses on what the principal did or said. The record has to contain some evidence that a principal intended to confer some sort of authority or, well, actual specific authority on an agent specifically to accept service of process for the defendant.
Is he the principal or is the employer the principal?
In this case, since it's individual service, our position is that Dr. Hinkle would be the principal. He would be the one who needs to delegate the ability to accept service on his behalf. We're not talking about service on the corporation here. We're talking about individual service on Dr. Hinkle.
But in other words, he was employed by UT-CHS, and according to the plaintiff, Mr. Payton was given authority by the employer to accept service on behalf of UT-CHS and on behalf of Dr. Hinkle. Are we saying that UT didn't have the authority to grant that authority to accept service on behalf of Dr. Hinkle? I assume that's what we're saying.
Yes, Your Honor, that's our argument. This isn't a case where we're talking about serving someone on behalf of UTHSC. We're talking about serving an individual. Speaking about serving a corporation is a different section of Rule 4.04, and the analysis focuses on when there's an individual, what that individual did to tell someone that they could accept service of process on their behalf. So yes, Your Honor, that is our argument. Here, there's simply no evidence that Dr. Hinkle impliedly authorized Mr. Payton to accept service of process on his behalf. Mr. Payton did have this understanding that he could accept paperwork on behalf of other physicians. These physicians were actually in different divisions than Dr. Hinkle, and this was when Mr. Payton was working in a different role. He was the director of operations at UTMP when he accepted service on, when he signed the summons on behalf of Dr. Hinkle. He was a practice manager when he signed paperwork for other physicians. He had done it 3 or 4 times. He did testify that this understanding was not due to any conversation that he had with Dr. Hinkle. Essentially, this came about because he would not accept service of some papers that came to his office, and he sent them to the corporate office. The corporate office didn't accept those papers and told him, the senior director in the corporate office told him to sign for those papers and give those papers to a physician. This course of conduct related to other physicians in other divisions when he was in a different role does not establish implied authority for him to accept service of process for Dr. Hinkle. There's nothing in the record that suggests that Dr. Hinkle knew about this procedure or acquiesced to it in any way. Nothing in the record even suggests that these papers that he accepted were service of the complaint of a lawsuit for anyone. Nothing establishes that when he accepted paperwork for someone else that it was actually appropriate for him to do so. Essentially, the implied authority, it has to be predicated on an act of an agent, and we just don't have any of that in the record here. The record doesn't include anything indicating that Dr. Hinkle took any action to give Mr. Payton authority to accept these papers.
Was Dr. Hinkle's employer named as a defendant in this suit?
It was not, Your Honor. Well, Methodist Hospital was, I believe at some point may have come out that they were not the employer, but UTHSC that we've been talking about was never a defendant in this lawsuit.
Okay, thank you.
Methodist is not a party in the lawsuit now, is that right?
Methodist is no longer a party. They were voluntarily dismissed without prejudice. The answer filed on behalf of Dr. Hinkle clearly states that Mr. Payton did not have authority to accept service of process on behalf of Dr. Hinkle. At that time, the summons could have been reissued and served on Dr. Hinkle, and it was not, and so therefore the dismissal was appropriate. It's our position plaintiff has not met the burden of proving that Dr. Hinkle was evasive or attempted to evade service of process, that plaintiff has not met the burden of proving that Dr. Hinkle authorized Mr. Payton to accept service of process on his behalf. So we're asking that this court affirm the trial court's dismissal of the lawsuit against Dr. Hinkle. If the court has any questions for me.
Let me ask you, in regard to implied authority, would we be looking at Mr. Payton's state of mind regarding whether or not he had implied authority, or would we be looking at Dr. Hinkle's state of mind?
I believe, Your Honor, that the case law focuses more on the actions of the principal, whether the principal did anything. As specifically as of state of mind, I don't know if that factors into the analysis, but it would be, the record needs to contain evidence that Dr. Hinkle intended to confer upon Mr. Payton the specific authority to accept service of process on behalf of him. So really the focus is on the actions of the defendant, the person being served.
Okay.
If the court has any other questions for me, I'm happy to answer them. Otherwise, I believe that I've addressed all the arguments I believe are germane to the court's determination of the issues, and I will wait the remainder of my time.
Thank you.
Thank you.
Mr. Zemansky. You have 3 minutes.
Thank you, Your Honor. I would just add one thing. It's not just actions and acquiescence. That's what the case law says. So in this case, the actions and the acquiescence is the fact that they called Mr. Payton to come in and accept service. That's who they called. He testified to that. And he came and he accepted service. And when he gave it to Dr. Hinkle, there was no protestation. There was no, that's acquiescence. There was no complaint that, oh, you shouldn't have accepted this for me. No, we don't do it this way. No, you're not authorized. None of that ever happened. But I do want to address one thing, because I saw this in the appellee's, I always get my sides mixed up. In the defendant's brief, what I saw was, and I think I heard it argued just now, is that under Rule 404 sub 1 of the Tennessee Rules of Civil Procedure, that you have to prove evasiveness and then prove that this person was the authorized agent. And I don't believe the rules read that way. And if you look at Rule 404.1, every one of the conditions, by delivering the summons to the person or by doing this, 404 sub 1 is one single sentence, and it's separated by the conjunction or. And the last or is, or by delivering copies to an agent authorized by appointment or law to receive service on behalf of the individual served. So if Mr. Padden was authorized by virtue of his position with UTHC, by virtue of the delegation of his higher-ups in his position above Dr. Hinkle, if he was authorized, if he was authorized to accept it, then that is proof of service. We don't have to also prove that Dr. Hinkle was being evasive.
Do you have any case law from Tennessee do you have any case law that you can cite that supports your position of how this rule should be interpreted according to Tennessee law? Do you have any Tennessee cases to support that?
Well, I think the Hall case would support that. It doesn't discuss the specific issue we're saying. I'm just reading I'm reading the rule, and the rule says you can do it this way, or you can do it this way, or you can do it this way.
Well, I understand that's how you're interpreting the rule and how you're reading the rule, but I'm asking you if you have any case law where courts have interpreted the rule in the manner that you are proposing.
I have read a lot of cases, and I haven't read any cases that discuss whether it's an or not, and, whether the or conjunction means there are alternative ways to prove it. But I think in reading those cases, it seems apparent to me, and that's why I mentioned the Hall case, is that's the way the court, they don't discuss the issue specifically, and I can't cite you to a case that does. But I think if you read those cases, it's read in the alternative, and that's a plain English reading of it. Thank you.
We'll take the case under advisement, and we'll issue an opinion as soon as we can. Thank you. Thank you for your argument.
Thank you.
May call the next case.
Larry King et al. Versus Town of Selma, Tennessee.